The notice to request informal probate. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover Scale Form PC 557. Scale for State Court Administrative Office, PC for Probate Court. And this form, we're happy to give it to you free of charge if you're navigating through the informal probate administration process. With all of these forms, we strongly urge you to work with a skilled, competent probate lawyer to be able to guide you through this process. The process is not simple, it's not intuitive, it's actually quite confusing. So this particular form is used in a very narrow context. It's used in an informal administration through the use of an application in which all of the parties that are affected by the application have not signed a renunciation consenting to the opening of the estate by informal process, as well as the nomination of the selected personal representative. So this notice of intent process is the alternate way to open up the informal probate administration. So rather than having all of the renunciations, you provide notice to those people that are affected, that have a right to notice under Michigan statute. And if they fail to act timely within that time, or they passively just don't take any action, then you can proceed to open the estate informally by application for informal probate. Now, with all these all of these state court administrative office forms, they are created by various statutes. In this case, MCL 700.3310 and the court rule MCR 5.309. Now, again, you really have to understand the mechanics of these statutes and court rules to really understand how to navigate through this process. And not everyone should be going through informal probate administration. Informal is really designed for particular context. Usually when the family is in great harmony, there's not a lot of complexity, there aren't threats of intra-family fighting or lawsuits, there's no dispute over the admission of a will. So really selective, you have to be selective on when you want to go through informal probate, because there's no final adjudication, for example, of the will. There's a lot of open-ended, but it allows for people to administer their probate estate after somebody has died, to administer the estate without a lot of court intervention. So again, it's used in very particular context. In this case, the statute MCL 700.3310 and the court rule MCR 5.309. Let's work our way through the form. Top left corner is the county, top right corner is the case number. Now, it's a little odd that the form has the case number on it, because in fact, when you file the notice of intent, when you use it, there hasn't been a case number assigned. Nothing's been filed yet with the probate court. So why they put the file number and the case number on there is a little odd. I suspect that that number is added after you have filed it with the probate court. But in this particular case, you'd fill it out with the county, but without the case number. The next section, pretty intuitive, the name of the person that has died, generally reflected as set forth in the death certificate and maybe the will or any aliases that are used, but the estate name. And then here is really the essence of it. It says, I, meaning the person filling this out, intend to request my informal appointment as personal representative of the estate. So you're giving notice that you're going to be seeking the informal appointment of personal representative. And then it says a copy of the application is attached. Now, the application for informal probate and appointment of personal representative is covered in a different video that I've done. It's a separate form, separate part of this, but you're welcome to watch it. But it's the notice and the application that then have to be provided service-wise. And it says the notice is being served upon each person whose right to an appointment is equal, prior or equal to my own. So for example, under Michigan laws of intestacy, assuming there's no will, there is a prioritization statute. So you have to really understand the mechanics of who's entitled to notice of appointment of informal probate. And people get this wrong all the time. I see lawyers incorrectly fill this information out. And as long as you get renunciations or give notice of intent to those people of equal or higher right to appointment, then you can go through this process. The court will act upon the application until 14 days after the notice is mailed out, or 7 days if the notice was personally served. So you can do it by mail or, of course, personal service of the notice of intent And within that time frame, once that is expired, then after that time period, the court can take action to appoint the individual through informal probate. Now, it's giving notice that the actions you can take, meaning the recipient of this notice and application, you can pay a filing fee and file a petition for formal probate, formal proceedings to appoint a personal representative. You can pay a filing fee with an application of your own seeking appointment. You can file objections to this process, but you have to do it in a way that assures that the informal process will come to an end and it will then become a formal process. And again, it provides that you can contact an attorney for assistance in representing you in the matter, because being a personal representative, that person has the right to hire counsel and have those expenses paid from the estate. But everyone else has to pay those legal fees out of their own pocket. So again, it's really an important consideration if you receive this form to decide, do you trust that person to serve as personal representative? Is this a good idea for that person to be without court supervision in the form of an informal probate administration? And then it says the court will not be able to provide any legal advice. So often people think that the court personnel can give them legal advice or help, and in fact they can't. Only a lawyer can, and that's why we continue to urge people to work with a skilled, competent probate practitioner. Again, a section for the date, the applicant, the person filling this out, their information, and then the attorney's information if there is one. Now, it provides a notice to the applicant. It says you must attach this notice and a proof of service to the application for informal probate. So when you go to the court asking for the informal probate and appointment of personal representative, you would then attach the notice of intent as well as the proof of service, and whether it's done by mail, personal service, or publication under the particular court rule. So again, a lot going on here for the use of this process and this form, a lot to consider, and I hope that I've given you the ABCs, just basic information about this particular form. At the Probate Pro, we are passionate about everything probate. If you have questions about probate or trust issues, give us a call at the Probate Pro. Visit us at theprobatepro.com or call us at 1-833-PROBATE.